Sorry, just give me a Yes, lovely.
My own friend, Mr. Benjamin Tankle, appears on behalf of the Secretary of State. May I just check documentation with the court? Hopefully the court has a full bundle, supplementary bundle, and the authority bundle. In respect of the supplementary bundle, it was updated at the end of last week to add a few documents to the end of the bundle at the request of the interested party. So, in particular, the Memorandum of Understanding was added to the end of the supplementary bundle.
Yes.
I've been guilty of sending a couple of additional emails after those documents were filed. Firstly, to bring the court's attention to a recent Court of Appeal judgment in...
Mr. Howes, is there any particular reason why you're sitting in the second row, both of you? I find it incredibly difficult to hear submissions all day from the second row. Would you mind coming forward?
Of course not.
Thank you. We've moved beyond the days where you have to leave the silks row free when there is no silk. Thank you.
Thank you. Firstly, to bring the court's attention to a recent Court of Appeal judgment, MOC, which was handed down the very day that the authorities bundle was handed into court.
Yes, well, we got lots and lots of documents, and we've done our best to read them, so you can move straight to the submissions, Mr. Howes. As far as your application for permission to amend your grounds of appeal is concerned, and Mr. Tankle's application to put in a respondent's notice, we're minded to grant both those applications unless either of you want to say anything to the contrary.
My Lord, no.
Then they'll both be granted.
Grateful. Lord, if it pleases the court, may I deal firstly with the time issue as a discretionary bar to this claim. It may be the best place for my submissions to start. The judge found the time ran from the establishment of the English Effective Blood Support Scheme in 2017, at paragraph 27 of her judgment. And the respondent relies in particular on the Court of Appeal judgment in Delve, which can be found at tab 13, but I don't intend to go there.
In which case?
Delve, my lord.
Delve. Yeah, you're going to have to speak up a bit, even if you're in the front row, Mr. Howes.
In that case...
Is that tab 13? Just
tab 13, my lady, yes.
Tab
but
13.
You don't want to take
I don't intend to go there.
So Delve, tab 13, but we're not going there.
That's what the respondent relies on.
Thank you very much.
On that decision. And there the Court of Appeal decided that legislation which changed the pensionable age for females was a one-off event, not a continuing act. And the court was particularly concerned with the principle that otherwise, if it were not a one-off event, time would never stop to bring a claim against a piece of primary or secondary, not primary, secondary legislation. That is not a surprising result in my submission. One piece of legislation making a permanent change in the law at the moment that it comes into force is plainly a one-off event.
And did the judge rely on that case?
The judge did not expressly refer to it.
He didn't refer to it. Right.
Probably as a result of the Court of Appeal's analysis of the nature of the decision in Delve, the court did not refer to the Supreme Court decision in Johnson and the Secretary of State for the Home Department. May I take the court to the case of Johnson, which is one of the authorities that I sent by email.
The relevant cases, in my experience, are always not in the bundle and sent the moment before the case begins. And that's this case too, is it, Mr. Howard?
Lord, as is always the way.
Yes. Okay, Johnson, we've got it.
May I begin by asking the court to look at paragraphs 7 to 8. And your Lordship, Dingemans was the first instance judge on this occasion.
And was he upheld?
By the Supreme Court, yes.
Absolutely.
Court reversed by the Court of Appeal, but the Court of Appeal was reversed by the Supreme Court.
They shouldn't have messed around with the judgment.
And the facts of this case were that a person committed a criminal offence in the UK, subject to the deportation regime, but was a child born in Jamaica out of wedlock, and so was not automatically a British citizen. There were routes by which the claimant in that case could have become a British citizen, but he did not avail himself of those routes. And so the question arose on deportation, whether deportation was contrary to the European Convention on Human Rights, and in particular, whether the effect of the fact he was deprived of automatic British citizenship at birth was a continuing act, which continued until the point of the deportation order. So that was the issue in the case. The court will see from paragraph 7 of the judgment of the Supreme Court, Baroness Hale, that in July 2014, Mr. Justice Dingemans held that the discrimination against a child of unmarried parents was not justified at the time of his birth and continued to be unjustified. There had been a violation of Article 14 of the Convention, read with Article 8, that the certification of the claim, as clearly unfounded, was unlawful, and that was quashed. Then in paragraph 8, in 2016, the Court of Appeal allowed the appeal by the Secretary of State, finding that there had been no violation of Convention rights at the time of the claimant's birth in 1985, and no wrong for which the UK courts could have given a remedy then. The matter had to be judged at the time rather than as a continuing act. Any violation had taken effect before the Human Rights Act came into force. Hence, there was no violation of Convention rights, and thus the claim could be certified. May I take the court to paragraph 23 of the judgment? The relevant issue was identified by Baroness Hale at paragraph 23. The issue is therefore is whether an appeal against the decision under Section 32 of the 2007 Borders Act applies to the claimant on the basis that to deport the claimant now would be a breach of the UK's obligations under the Human Rights Convention and is clearly unfounded. That depends on, one, whether it is sufficiently within the ambit of Article 8, and two, whether discrimination had a one-off effect at birth or whether it had continuing consequences which may amount to a present violation of Convention rights. Then that issue was decided by the court at paragraph 28 under the heading "A Continuing Effect?" And the court said, the Court of Appeal held that the denial of automatic citizenship was a one-off event that happened at birth and had no continuing effect capable of being a violation of Convention rights. For example, in Posti in Finland, 2002, the restriction on the applicant's rights to fish in state-owned waters imposed by a decree in 1994 obviously continued to limit their fishing, but was a single event and their complaint was out of time. I pause here to interject this. That's similar to the issue in Delve, piece of legislation changing pension rights and fishing rights. However, the court reiterated that the concept of a continuing situation refers to a state of affairs which operates by continuous activities by or on the part of the state to render the applicants victims. Of that, they cited paragraph 39 of the Posti case. Thus, in Norrisun Island in 1988, it was held that the very existence of the legislation penalising homosexual acts continually and directly affected the applicant's private life, despite the fact he had neither been prosecuted nor threatened with prosecution. In this case, the denial of citizenship has a current and direct effect upon the claimant, who is currently liable to action by the state in the shape of deportation as a result.
So what's the continuing act here?
Well, Lord, in my submission, there are a number of reasons why there's a continuing act in this case.
No, sorry. What is the continuing act here?
The failure to include those infected with hepatitis B through blood and blood products provided by the NHS.
Sorry, just go a bit more slowly. The failure to include those
Infected with hepatitis
affected
B
by hepatitis B, yes.
by blood or blood products
Yeah,
provided by the NHS
yeah.
in any support scheme.
In any support scheme.
In particular, the English Infected Blood Support Scheme.
I think you have to say in any continuing support scheme, and then you get round the Delve problem. The fact is they're continuing annual payments, and that is the arguable distinction that you would be entitled to draw.
Lord, precisely.
Yeah.
And the reason why I say any scheme, my Lord, is because, of course, the predecessor to the current Infected Blood Support Scheme was the Skipton Fund for Hepatitis C in 2004, and the McFarlane Trust for HIV in the early 90s. So may I make a number of submissions in relation to that. Firstly, the appellant continues to reside in grinding hardship, in the shadow of shattered dreams caused by his physical disability, the result of infected blood given by the NHS. Secondly, notwithstanding that the scheme is tweaked from time to time, for example, in 2019, there was a significant increase in annual payments. The position of those infected with hepatitis B is ignored. Thirdly, the scheme remains open to new applications, but the appellant and others with hepatitis B are continually barred from applying. And then fourth, the discrimination complained of in this case existed before 2017 and has continued since 2017. Nothing changed for those infected with hepatitis B in 2017. And indeed, their position was not even considered then or since. The idea that this claim crystallised in 2017 is, in my submission, misplaced.
So none of that really has anything to do with the letter and the response.
Well, the way that the claim was put in the grounds and has always been put, and all the references are in the note that I submitted yesterday, was that this is an ongoing failure. And the letter in May 2020 was a particular decision that exemplified the point. The appellant's claim has never been limited to that particular decision. The grounds, paragraph 1, used the phrase, in particular, the decision in May 2020. It's never been the only decision challenge, or target, rather. It's a manifestation of the ongoing discrimination. Therefore, it is submitted that the ongoing operation of the scheme and the direct effect that it has on the appellant by his continued omission is materially different from the one-off legislative act in Delve. And the learned judge, in this case, erred in principle on that point. Those are my submissions on continue and act. I accept that a challenge to the exercise of discretion on the extension of time is more difficult, but I make 3 short submissions in that regard. Firstly, if this court takes a contrary view of the merits, that affects the exercise of discretion on time, and that point is accepted by the respondent as correct. The merits of a case are relevant to the exercise of discretion.
Yeah.
Secondly, the public interest and the interest of justice are not furthered by refusing permission for a claim on behalf of a person infected with hepatitis B in circumstances where it is known that a materially similar claim by a person infected with hepatitis C was granted permission, held to be in time, and an extension of time granted in any event.
That's chalice.
That's chalice.
Was it materially similar? Because their hepatitis C was included and the complaint was of the bright line of the cut-off date.
It's materially similar, my lord, yes, for this reason, and I will come on to the ministerial submission which was filed this morning to prove the point in a moment. It's materially similar because in chalice they challenge the cut-off date of 1991, it is plain from the ministerial submission that the reason for that cut-off date is because after that date, the blood was screened. It's exactly the same justification as the justification in this case.
Yeah.
You're not entitled to be within an ex gratia scheme because your blood was screened. And in the ministerial submission, it is further said that to allow those who received screen blood to benefit from an ex gratia scheme would be to effectively set up a no-fault compensation scheme because they have unmeritorious claims. I'll come on to that later when we deal with justification, because that is an about turn in my submission as to how the respondent has run the case in this claim. So that's why they're materially similar. It's the same justification, the same issue as to the legal status of those individuals who received screen blood.
Third point?
My Lord, before I move off Chalice, if I may, in that claim, they argue both discrimination, albeit under the 2010 Act, and rationality. It is not accepted that the rationality challenge is as narrow as the respondent says it is. And I would refer the court to paragraphs 27 to 28 of the Chalice grounds, which can be found in the supplementary bundle at page 294. It is a broad rationality challenge of the cut-off.
I mean, are we going to actually look at Chalice at some point, or?
My Lord, may I take it to the grounds now?
Okay.
So it's in the supplementary bundle at page 294.
Yes.
Paragraphs 27 and 28. Could I invite the court to read those paragraphs?
27 and 28, yes.
It is a broad rationality challenge, similar to the one in this case. Although Mr. Justice Mostyn, in his reasons for granting permission in Chalice, identified a more narrow point about there was a blur, the cut-off point in reality was blurred because there was old blood that wasn't screened and you didn't know if you got old blood or new blood. Those were his reasons for granting permission. The claim is not limited to that narrow point, and I've spoken with leading counsel in Chalice and he has confirmed that. And so that leads to the submission that as public authorities should treat like cases alike, my submission, the administrative court on this occasion should have treated like cases alike. Those who were infected with hepatitis B have been treated differently to those who were infected with hepatitis C. My third submission on time, on the extension, is that it would be anomalous to treat a discrimination claim under the Equality Act 2010 as being within time on the basis of section 118, subsection 6 of the Act. May I, still with the Chalice grounds, may I ask your Lordships and your Ladyship to go...
Sorry, I haven't quite got this submission. Can you just repeat it for me? It would be anomalous to treat a discrimination claim under the Equality Act and then?
2010 as being within time on the basis of section 118, subsection 6, but then treat a discrimination claim under Article...
Sorry, let's just take it slowly, shall we? It would be anomalous to treat a discrimination claim under the Equality Act as being within time and then to treat this claim as being out of time.
Treat a discrimination claim under Article 14 of the European Convention on Human Rights as being out of time. In the supplementary bundle of page...
So why are we treating the discrimination claim under the Equality... Which discrimination claim are you talking about?
In Chalice.
Chalice. Oh, we're back in Chalice.
Well, forgive me, yes, I'm talking about the difference between Chalice... Still talking about the difference between Chalice and
I see,
this
I thought
case.
you'd moved on to your third point. Okay.
So that's page 305 of the supplementary bundle. the grounds and chalice set out section 118, subsection 6, which provides, for the purpose of this section, conduct extending over a period is to be treated as done at the end of the period. And that is the basis upon which Mr. Justice Mostyn held that it was within time.
Arguably within time.
Well, the decision on permission was that it was within time, and that can't be revisited at a substantive hearing, of course, unless the position was reserved. So it's, in my submission, anomalous to treat two discrimination claims differently. Those are my submissions on time.
So the third point never happened.
The third point is that it's anomalous to treat the two discrimination claims differently. May I now move on to deal with ambit. And firstly deal with Article 8 of the European Convention on Human Rights. And may I begin by taking the court to the directions made under the National Health Service Act 2006, the NHS Business Services Authority, the Effective Blood Payment Scheme Directions 2017. They are in the authorities bundle at page 11, tab 3.
So we're looking at the National Health Service Act 2006.
Well, no, the directions, tab 3, 2017 directions.
Oh, I see it. Okay. Directions.
Under paragraph 1, subparagraph 3, there are a number of definitions, and the infected blood payment scheme is there defined. It means a scheme to make payments and to provide support in respect of individuals infected with HIV or hepatitis C or both from blood or blood products used by the NHS, and to provide support to family members of such individuals, which is being established to replace the previous trusts. May I next take the court to the explanatory memorandum to the Social Security, Infected Blood and Thalidomide Regulations 2017. It's, those regulations are at the next tab. Those are the regulations that amended Social Security legislation to ensure that payments from the infected blood support schemes were disregarded in means testing under Social Security legislation. Then the explanatory memorandums behind the next tab, tab 5, and the relevant passage is at page 17. Paragraph 7.2. Five lines down towards the right-hand margin, or 3 lines up from the bottom of that page. As they do not supplement income in the way that those benefits...
I can't read half sentences. All payments made to individuals via the schemes mentioned above are currently fully disregarded for the purposes of calculating eligibility, as they do not supplement income in the way that those benefits do. Yeah.
But are intended to compensate infected persons and their relatives in recognition that the physical, mental and other health impacts for those infected can lead to additional costs which cannot be met through the benefit system.
So the equivalent of putting it into a personal injury trust to avoid losing benefits in a PI claim.
I suppose so, my lord.
Yes.
But the point I seek to make relating to these two documents is that the purpose of these payments, of the scheme, is not only to provide payments and support to those infected, but also to their family members, who are also affected by the infection. And that, in my submission, brings it within the ambit of Article 8. may rely on two authorities for that proposition. The first is the Crown on the application of the Joint Council for the Welfare of Immigrants and the Secretary of State for the Home Department, tab 11, page 184. Paragraph 87. The judgment of Lord Justice Hickenbottom, it is probably strictly obiter, what he says here. But nevertheless, he says that second, where a state...
87.
87, my lord.
Yeah.
Second, where a state takes positive action, which, whilst not required by Article 8, in the sense that a failure to take such action would not have constituted an interference with the rights within the scope of Article 8.1, demonstrates its respect for private and family life, etc., this will fall within the ambit of Article 8. In my submission, that applies to the support scheme payments because of the purpose that I've identified a moment ago. It's the state demonstrating its respect to the family members of those infected and the impact on them. May I stay with the judgment of Lord Justice Hickenbottom and invite the court to scroll down to paragraph 104. And this is the relevant test to be within ambit. Lord Justice Hickenbottom said, the Strasbourg authorities indicate that where a positive measure of the state is being considered, it is sufficient that the measure has more than a tenuous connection with the core values protected by the substantive article, here, Article 8. I appreciate that this is not a classic modality case, but it does involve a positive measure by the state in the form of a scheme. Whilst perhaps generous to the Joint Council, I shall proceed on the basis that the more than tenuous link is the appropriate test. It certainly reflects the generous width of the concept of ambit, consistently applied by the European Court of Human Rights. So to be within the ambit of a substantive right, there has to be more than a tenuous connection between the measure being challenged and the substantive rights. Second authority, my lords and my lady, is the Crown on the application of SC and the Secretary of State of Work and Pensions, the recent Supreme Court judgment. It's at tab 15, page 312. This is the two-child rule case where you couldn't apply for child benefits for more than 2 children, and it was argued that that was discriminatory against families with 3 children. Lord Reid gave the judgment of the court, and at paragraph 48, forgive me, paragraphs 40 and 41. Page 312. Top of the page, 312, second line. Nevertheless, since by granting parental leave allowance, states are able to demonstrate the respect for family life within the meaning of Article 8, it followed that the allowance, therefore, comes in the scope of that provision. And he's referring to paragraph 9 of the Petrovich case in the European Court of Human Rights. The consequence that Article 14, taken with Article 8, was applicable. A number of other judgments of the European Court confirmed that welfare benefits, which are designed to facilitate or contribute to family life by supporting families with children, are likely to fall within the ambit of Article 8 for the purpose of complaints under that article taken together with Article 14. In my submission, that's Supreme Court authority supporting what Lord Justice Hickenbottom said in the JCWI case.
And was that mentioned? Was the other case mentioned here? Higginbottom's judgment?
Yes. Mrs. Justice Stacey had JCWI and I...
No, in SC.
Yes. Yes. In particular, a passage of Lord Justice Higginbottom's in JCWI regarding the similarity between justification under irrationality and justification under Article 14 were effectively the same once you appreciate that the wide margin of appreciation applies in both contexts. That was approved by Lord Reid.
But in fact, what Lord Justice Higginbotham had done was simply follow the ECHR jurisprudence, and so had Lord Reid.
My Lord, yes.
So it wasn't dependent on him approving what
No.
Lord Justice Higginbotham had said. It was just consistent with the authorities.
And one feature of the scheme that I've yet to mention under the English Effective Blood Support Scheme is that there are means-tested payments for children. So there are payments per child, and that you can find that scheme at, in the supplementary bundle at page 105. So at page 105 of the supplementary bundle, or a third of the way down, there's a heading, Payments for Children of Beneficiaries with HIV and or Hepatitis C and bereaved beneficiaries. These means-tested payments are to help with the cost of bringing up children of an infected beneficiary. Dependents of children of an infected beneficiary up to the age of 18 years or up to the age of 21 if in full-time education. These payments are available to primary care provider of the children and can only be made where the beneficiary has qualified for an income top-up payment. Affected beneficiaries may qualify for a child supplement by completing an income top-up and child supplement form, and then it sets out the payments. So for the first child, annual amount is £3,000 with a monthly rate of £250, and each subsequent child, the figures are there. So again, this is more evidence that there are payments and support within the scheme that are designed to assist families. And the fact that, in particular, if a child over the age of 18 but under the age of 21 goes to education, that has additional costs that the infected beneficiary may not be able to meet, so the scheme steps in and helps the family in that regard. Therefore, in my submission, as a result of all of that, it is at least arguable that the scheme is a modality by which the respondent supports the families of affected persons, and so is therefore more than tenuously connected with Article 8. May I next deal with Article 1 of the first protocol to the Convention? And may I take the court straight away to two authorities. The first authority is the Crown on the application of RJM, the Secretary of State of Work and Pensions, tab 8. We can see in the head note on page 81 the claimant received a disability premium in his income support by reason of his incapacity for work through mental health problems. He became homeless, and the Secretary of State stopped payment of the premium on the ground that he was without accommodation within the meaning of the Income Support Regulations 1987, and therefore disentitled to it. The claimant sought judicial review of that refusal to reinstate the payment, claiming that the non-contributory premium is capable of being in possession in A1P1, so that his right to peaceful enjoyment of his possessions was engaged. That withholding the premium by reason of his homelessness was discriminatory and contrary to Article 14. May I take the court to paragraph 23 of the judgment, which is on page 93. I should say the appeal was not allowed because the Supreme Court described the decision as callous, to disentitle someone who's homeless from the benefit, but that the purpose that was identified by the Secretary of State in that case was to encourage homeless people to find accommodation. And they would, the state would rather spend money on helping them get accommodation than paying them the premium when they are homeless. And so there was a justification for it but I rely on this case for what it says about Article 1, Protocol 1. First of all, paragraph 23 in the judgment of Lord Neuberger Lord Neuberger states, it is, plainly rightly, common ground that disability benefit is capable of being a property for the purposes of A1P1. However, the basic point made by Mr. John Howell, on behalf of the Secretary of State, is that the consistent jurisprudence of the European Court of Human Rights is to the effect that a claim, whether made under Article 1, Protocol 1, or under Article 14 relying on Article 1, Protocol 1, cannot succeed if the claimant has no right or legitimate expectation. And that's, in my submission, quite important. It's in dispute between the parties in this appeal. Or legitimate expectation to the possession in respect of which his claim is made. As RJM has neither a right nor a legitimate expectation to a disability premium, indeed the absence of any such right is the basis of his complaint, runs the argument, his claim cannot be brought within the ambit of Article 1, Article 1, and hence Article 14 must fail. That argument did not find favour with the court, because the whole point of discrimination is but for the discriminatory criteria. At 25, Lord Neuberger said, referring to a case, forgive my pronunciation, of Kopecky in Slovakia, that the European Court of Human Rights said that A1P1 does not guarantee the right to acquire property, so that a claim cannot be brought within A1P1 unless the claimant owned or at least enjoyed a legitimate expectation to property. So that's jurisprudence of the European Court of Human Rights holding that a legitimate expectation is enough. The court then explained in paragraph 49 that there could be no legitimate expectation unless there was a currently enforceable claim that was sufficiently established.
Sorry, where are we now? 49, did you say?
Paragraph 25.
Oh, we're still at 25. Yep, thank you.
May I next take the court to paragraph 28. Simply to say that the problem was identified by the court as this: the problem faced by the Secretary of State arises, as I've indicated, from the reasoning decision in Steck. And then at paragraph 29, after recording the argument made by the UK in Steck, Lord Neuberger stated that this argument was rejected by the European Court of Human Rights. The court's reasoning, in summary terms, was as follows. First, it would be sufficient for a claim under Article 14 to succeed if discrimination occurs not only in relation to the rights which the Convention guarantees, but also those additional rights which the state has voluntarily decided to provide. And accordingly, it was necessary to decide whether the interests of the applicants fell within the ambit or scope of Article 1, Protocol 1. And then at paragraph 30, the Supreme Court cited extensively from the decision in Steck, an important decision for our purposes. And may I refer the court to paragraph 50 of that citation, where the European Court said, many domestic legal systems recognise that some individuals require a degree of certainty and security and provide for benefits to be paid, subject to the fulfilment of the conditions of eligibility as of right. Where an individual has an assertable right under domestic law to a welfare benefit, the importance of that interest should also be reflected by holding A1P1 to be applicable. And then at paragraph 54, in cases such as the present, concerning a complaint under Article 14 in conjunction with A1P1, that the applicant has been denied all or part of a particular benefit on a discriminatory ground covered by Article 14, the relevant test is whether, but for the condition of entitlement about which the applicant complains, he or she would have a right, enforceable under domestic law, to receive the benefit in question. Although A1P1 does not include the right to receive a social security payment of any kind, if a state does decide to create a benefits scheme, it must do so in a manner which is compatible with Article 14. And that's the important point in my submission. And here, where the state has decided to establish the infected blood support scheme, which is within the broad definition of a welfare benefit, and we'll come on to JT, which discusses that in a moment, it must do so in a non-discriminatory way. In my submission, that is enough for the purposes of today to demonstrate that it is arguable that this claim is within the ambit of Article 1, Protocol 1. I mentioned JT in the first tier tribunal. May I take the court there now? It's at tab 10. It's a 2018 Court of Appeal decision.
So which tab?
Tab 10, my lord. And this is a claim in relation to the Criminal Injuries Compensation Authority, and the fact that before 1979, if someone was subject to a sexual crime by a member of their own family with whom they lived under the same roof, they were excluded from criminal injuries compensation. And so the argument ran that, and particularly on the facts of this case, the same person sexually assaulted her friend, and the friend qualified for compensation, that rule was discriminatory against people who lived in the same household as the offender. Now, first of all, we'll take the court to paragraph 15 of the judgment, which is on page 122. It's the judgment of Lord Justice Leggett. And this is where he describes the scheme that had been set up for criminal injuries compensation. The paragraph 15, he says, awards of compensation for criminal injuries were put on a statutory basis in England and Wales and Scotland by the Criminal Injuries Compensation Act 1995. Section 1 of the 1995 Act provides that the Secretary of State shall make arrangements for the payment of compensation to or in respect of persons who have sustained one or more criminal injuries, and that such arrangements shall include the making of a scheme, providing in particular for A, the circumstances in which awards may be made, and B, the categories of person to whom awards may be made. Section 11 provides parliamentary control of the scheme by requiring a draft of the scheme to be approved by a resolution of each House of Parliament. The point I make about this is that the English Effective Blood Support Scheme is materially similar in terms of how it's established by statute. In the case of the Effective Blood Support Scheme, there are directions that I've taken the court to that direct the NHS Business Services Authority to run the scheme. And those directions are made under the NHS Act, and as the court will know, secondary legislation has the force of primary legislation. The scheme is left to a memorandum of understanding between the Secretary of State and the NHS Business Support. But the duty to create the scheme is contained in the legislation. And so in my submission, the Criminal Injuries Compensation Scheme, where it was left, the design of the scheme was left to the executive involved. It was not set out in the legislation. It's the same. Both are on a statutory footing, and the scheme is designed outside of the statute. So the rights and the eligibility criteria and the rights they generate are in the scheme, not in the statute. The scheme has to be established because of the statute. May I next take the court, same judgment, to paragraph 47. Page 129. Halfway down the paragraph, the court states that the CICA contends, so this is noting what the argument was, contends that the approach established by the Steck case, just above G, contends that the approach established by the Steck case is limited to welfare benefits and does not extend to compensation claims which fall outside the framework of social security legislation. So that was the submission on behalf of CI. CA. Then at paragraph 50, the Court of Appeal said this about STEC and that submission. Although the STEC case was concerned with welfare benefits, I can see no logical reason why the second step in the court's approach should be confined to cases involving such benefits. It seems to me to be an application of the general principle mentioned earlier, that where a state creates rights under its domestic law, which fall within the ambit of a convention article, it must do so in a non-discriminatory manner. It follows from this general principle that Article 14 is engaged if a person would have such a right, but for the discrimination covered by Article 14. The point being made by the Court of Appeal is that STEC is not to be limited to, for example, social security legislation in this country. Next, at paragraph 57, after referring to a number of Supreme Court authorities, at B, the Court continued, in those cases, the Supreme Court recognised a distinction between social security and welfare benefits, whose substance is defined precisely, and which can therefore amount to an individual right, which the applicant can consider herself the holder, and those benefits which are, in their essence, dependent upon the exercise of judgment by the relevant authority. Cases in the latter category, where the award is dependent upon a series of evaluated judgments by the provider as to whether a statutory criteria is satisfied and how the applicant's needs ought to be met, do not fall within the scope of Article 6. The point being made there is that there's a difference between automatic eligibility if you meet the precedent fact, but then schemes which require an evaluative judgment. And then paragraph 64, analysing the nature of the criminal injuries compensation scheme, the court said, paragraph 64, the terms welfare benefit and social security are not terms of art. They are capable of describing almost any form of financial support or help provided to citizens by the state to promote or protect their welfare. And I rely upon that to make the submission that the English Infected Blood Support Scheme is a welfare benefit. Then at 65, in the sense relevant for present purposes, payments made by the state under the United Kingdom's Criminal Injuries Compensation Scheme are, in my view, to be regarded as welfare benefits. Such payments are no different in principle from, for example, benefits payable to persons who have suffered industrial injuries, with which STEC was itself concerned, or to people who have disabilities. Then at 66, just above H, applying that distinction, I think it clear that the United Kingdom Criminal Injuries Compensation Scheme is not a special scheme set up to provide one-off payments of reparation for a particular historic event. It forms part of the general framework of social security legislation in this country. The fact that it falls within the budget and remit of the Ministry of Justice rather than the Department of Work and Pensions, and is governed by a different Act of Parliament from the Social Security Contributions and Benefits Act, the Social Security Administrations Act, cannot be dispositive. What matters is how the scheme is administered and regulated. Sorry, what matters is not how the scheme is administered and regulated, but the nature of the scheme. The question is then whether, applying the test established by the STEC case, the legislation provides for payments to be made as of right. Although payments made under the criminal injuries scheme were originally discretionary and ex gratia in nature, that is no longer the case. Since the scheme was placed on a statutory footing in 1995, a victim of crime who fulfills the eligibility conditions has a right to an award under English domestic law. And in my submission, that right arises not because of a provision in a statute, but because of what is said in the eligibility criteria in the scheme that is established pursuant to a duty in the legislation, which is the same as the position in the Infected Blood Support Scheme. I go back to the point that the European case law requires a legitimate expectation. May I now leave that authority and make the following submissions based on all of that. That Article 1 submission that this claim is within the ambit of Article 1 Protocol 1 is arguable. Firstly, a legitimate expectation, but for this discriminatory provision, is sufficient. It is at least arguable that applicants have a legitimate expectation that the published eligibility criteria of a scheme are applied to them. Secondly, applications to the English Infected Blood Support Scheme, save for the discretionary payments which are built into the scheme, do not involve evaluative judgments more than any other scheme that has a precedent fact for eligibility. So qualification for any scheme, you have to satisfy that you meet the eligibility criteria as a precedent fact. It's not the same thing as an evaluative exercise. And thirdly, the authority of JT and the First Tier Tribunal assists the appellant rather than undermines his claim, because my respondent relies on JT in his submissions. It demonstrates that schemes established pursuant to duties in legislation generate assertable rights. And a point that I've already made, that the Infected Blood Support Scheme and the Criminal Injuries and Compensation Scheme, both schemes set out pursuant to statutory duties to establish them. And those are my submissions on Article 1 Protocol 1. It's at least arguable that there's a more than tenuous connection between the scheme and Article 1 Protocol. May I now move away from ambit and deal with a relatively similar situation.
Relatively or relevantly?
Relatively. Although no point is taken on status for the purposes of this appeal, it is necessary to identify the ground upon which the appellant has been treated differently. Status has to be a personal characteristic, and there has to be certainty about that characteristic. And for this purpose, may I take the court to the authority of MOC, which is one of the ones that I submitted later. This is the recent Court of Appeal judgment of Lord Justice Singh. May I take the court to paragraphs 52. The Lord Justice Singh makes some general, identifies some general principles on status. I invite the court to read paragraphs 52 and 53.
Yeah.
It's in particular clear from what Lord Lloyd Jones said in the Crown application of A, that there has to be a characteristic which is something more than a mere description of the difference in treatment. This is a case about whether or not the fact that someone lacks capacity for certain functions amounts to a status. And at paragraph 65, first of all, could I invite the court to read paragraph 64 and 65 to get the context? I rely in particular on the final sentence of paragraph 65. Secondly, there needs to be reasonable certainty. A person's capacity may change from time to time and may do so quickly. This is not a sound foundation for the status required by Article 14. Further, status, characteristic, has to be the ground upon which the appellant is treated differently. It has to be the ground that results in him being treated differently. The English Infected Blood Support Scheme is open to persons affected with HIV and with hepatitis C by blood and blood products provided by the NHS. I took the court to the directions and the definition of the scheme. It is clear in my submission, and it is at the very least arguable, that the ground upon which the appellant is treated differently is that he was infected by hepatitis B by blood and blood products provided by the NHS. That is his status. That is the ground upon which he does not qualify for the scheme. It is a personal characteristic, infection with hepatitis B, and it is certain. The respondent's suggested ground that he received screened blood, which I submit was ineffective, and that he can bring a civil claim against the National Blood Transfusion Service, which I submit is fraught with difficulty, is too uncertain to be a personal characteristic. Someone's legal standing in respect of civil claims is not a personal characteristic. When the ground for the difference in treatment is properly identified, it can be seen that a person infected with hepatitis B by blood and blood products provided by the NHS is in a relatively similar situation as someone infected by HIV or hepatitis C by blood and blood products provided by the NHS. They were all infected with a virus which, in many if not most cases, cause significant physical and mental disability, discrimination by society, and financial hardship. Seen through the lens of the purpose of the scheme, and I've made submissions about the purpose of the scheme, which is to make payments and provide support to infected individuals and family members, there is no material difference.
I mean, I don't really understand that. There is a significant material difference in the question of screening. And you say, well, it can't be a personal characteristic because it's uncertain. What's uncertain about it? I mean, it's absolutely clear that after a certain time, blood was screened. Not effectively, you say. Well, that's a perfectly reasonable thing to say and obviously correct, but doesn't necessarily affect the status. I mean, the government has to make distinctions. This was a scheme, apparently, which was intended to benefit people who were provided with unscreened blood up to a particular cut-off point.
My Lord, may I make a number of
Came in.
points in relation to that?
Yeah.
Firstly, the respondent's submission is not just that they were screening. The respondent's submission is, as a result of screening, those who were infected can bring legal claims. That's the respondent's argument. So the reason why I say it's uncertain is because it's dependent on the merits or otherwise of the legal claim that the respondent says they could have brought.
Well, that's not dependent. The legal claim, the success of the legal claim may be dependent on things that are uncertain. But the fact that some people were given screened blood and some people were given unscreened blood is not uncertain.
My Lord, in my submission, the fact that blood was screened is a reason for restricting the scheme to hepatitis B, hepatitis C and HIV. It's not the ground upon which the claimant was treated differently. The ground in the definition of the scheme, the only bit that the claimant doesn't satisfy is the virus with which he was infected. He satisfies everything else, but he doesn't have hepatitis C or HIV. So the ground on which he's...
I thought the scheme had a cut-off point for HIV and HCV sufferers.
Yes, so there are certain boundaries in the scheme when it's drawn up in the memorandum of
the cut-off point is a cut-off point designed to exclude people who were given screened blood, which was after particular dates.
The cut-off point in my submission is a boundary of the scheme. It's one of the eligibility criteria.
Yeah.
But the purpose of the scheme is to provide financial payments and support to infected persons who receive blood and blood products from the NHS, who were infected with hepatitis C and HIV.
Who hadn't had the benefit of screening.
Well, the screening, I say, is the reason why the scheme is defined in that way. It's not the ground upon which the claimant is treated differently, because the ground upon which he's treated differently is the nature of the virus he was infected with. The reasons for that is that there was screening. So in my submission, it's important to draw a distinction between the relevantly similar situation and justification. It's important to draw a distinction between the ground for the difference in treatment and the reasons why the scheme is drawn up as it is. The reasons why the scheme is drawn up as it is, as your Lordship has identified, that the blood given to, the blood was screened for hepatitis B. But that's a reason, a justification for the way that the scheme is and for the difference in treatment. It's not the ground upon which the claimant has been treated differently. The ground upon which he's been treated differently is the virus, the identity of the virus. The reasons for that go to justification. It's the difference between the ground and the reasons. And on this point, it is important to identify that screening is not the only reason put forward by the government. The government put forward a number of different reasons for drawing the boundaries of the scheme where it is drawn, including the size of the respective cohorts. So the government does not put all its eggs into the screening basket. There are a number of reasons it puts forward, and not all of those reasons can be the ground upon which it's treated differently. They are the underlying reasons for designing the scheme in the way it is.
But it doesn't rely on the numbers as being the ground for different treatment. It may give that as an explanation of the ambit of the scheme, of the parameters of the scheme. But as I understand it, the case you have to meet on relatively similar is that the reason for the exclusion of your client effectively is, or the reason for you is twofold. One is that he doesn't suffer from the two conditions that were the subject of the scheme, and the other is that he was given screened blood.
Well, my Lord, in my submission, the government do say that the size of the cohort is a reason, because they expressly say in the written material that the special circumstances that apply to those infected with hepatitis C did not apply to those infected with hepatitis B, by which they mean the numbers of people who were infected. So that is expressly
one of the number of people that were affected is because there was a large number of people who were given unscreened blood for hepatitis C, and therefore they're covered by the scheme. But it's circular to say that the distinction is just C against B. The distinction is whether you got screened blood, because this is a scheme that compensates people who can't sue the NHS because the blood was not screened, and therefore they didn't do anything wrong, they just didn't screen the blood. I suppose that could be a claim for negligence, I don't know, but it depends on the state of scientific knowledge.
My Lord, I believe it's in RJM. I think it's about paragraph 5, the judgment in RJM. The Supreme Court said that a personal characteristic is what someone is, not what's done to them. Giving someone blood, which is screened or not screened, is doing something to someone. That is not a personal characteristic. Personal characteristic is what disability that person is then left with.
Well, I mean, HBV is not what someone is.
Well, it's a personal characteristic. They
Well,
are
I mean, that's
disabled.
circular. You can't argue in that way. I mean, this is a person who's suffering from HBV because he was given untreated blood. I'm sorry, he was given treated blood which still had HBV in it.
The difficulty, another difficulty with treating the fact that blood was screened as a characteristic rather than a justification is that in this case, and we may come on to it, is that screening was so ineffective that I submit that it was irrational to...
Well, I mean, how do we know that?
I'll take your lordship to the evidence in a moment.
I mean, I thought there were 10 people who were affected in the same way as claimant.
There's a letter from the affected blood inquiry that was issued when this claim was issued, so some time ago. What the affected blood inquiry said was that they were reviewing 3,000 witness statements. They were still in the process of reviewing them. So far, they had found 12 people who'd been infected with hepatitis B through blood transfusions and 13 people who'd been infected with hepatitis B through blood products, so 25. That was a provisional figure.
Do we have any update on that?
Lord, no.
No.
The point I was making, my Lord, and I will take your lordship to the evidence in a moment, if I may, is that if you treat the fact that blood was screened as a characteristic, not as a justification, then precludes the appellant from attacking that reason for the difference in treatment.
But what is the test we're applying? I mean, the question, as I understand it, is found in Lord Reed's judgment in SC. Is that right?
My Lord, yes, amongst other places.
Well, amongst other places, but Lord Reed would be fairly authoritative for this purpose, wouldn't he? And
I'm just scrolling to the relevant paragraph.
so the difference. So we're looking at the question as to whether the complainant has been treated differently from other people not sharing his status who are similarly situated. And the difference is only relevant for the purpose of assessing whether there's been discrimination if the claimant is comparing himself with others who are in a relatively similar situation. And an assessment of whether situations are relevantly similar, incredibly confusing language, relatively similar, I suppose, generally depends on whether there's a material difference between them as regards to the aims of the measure in question.
Yes.
So why is there not a material difference between screened and unscreened blood as regards the aims of the measure in question?
My Lord, because of the way that the infected blood support scheme is defined in the 2017 regulations, the purpose of the scheme is to provide payments and support to infected individuals and their family members. So if that's the purpose of the scheme, there is no material difference between someone infected with hepatitis B and hepatitis C.
Sorry, you see, you really are running on. So Lord Reed said what I've just read to you, and the answer to the question of whether there is a material difference between, so you say there is a material difference between them as regard, there is no material difference, is this your point, between them because the aims of the scheme are to help families of the people who are covered by it.
But, my lord, it's
You're taking us back to the definition. You took us back
yes,
to
maybe.
right at the beginning.
It
You're
is page 11.
anchoring these submissions to that definition, I think, really.
My lady, yes.
On page 11.
On
Page 11.
Yeah.
Well, let's look at it.
The definition picks up infected with HIV or hepatitis C.
Yes, and that's the discriminatory criterion, so that's the bit that we're challenging.
So it means a scheme to make payments and provide support in respect of individuals infected with HIV or HBC from blood products, but it doesn't say unscreened blood products.
Lord, no.
And that's your point.
Lord, yes.
Can I just clarify your submission? Because I know there's an issue raised by the respondent about whether, in fact, the appellant in this case was infected by the blood product. You say that it's arguable that he was, and that's sufficient for the grant of permission.
Lord, yes. And I also say that the administrative court can quite clearly make a finding on the balance of probabilities that he received his infection.
You helpfully in your skeleton argument gave us a list of reading, and that all seems to point in that direction.
My lady, yes. That's why I did so. There are a number of medical letters which quite clearly state that he was infected by NHS blood.
So how does the cut-off point come in under the directions or regulations?
So the directions leave the design of the scheme and the boundaries of the scheme to the Memorandum of Understanding between the Secretary of State and the NHS Business Services Authority. So that's where the boundaries of the scheme and the eligibility criteria come in.
So where are the eligibility criteria,
Well, that's
including
in
the cut-off points to be found?
My lord, in the supplementary bundle, there was the additional material that was filed at the end of last week. It's not a complete document.
Sorry?
The material provided by the interested party is not a complete version of the Memorandum of Understanding.
Okay, so what are we looking at? Not the supplemental bundle.
Supplementary bundle.
We are looking at the supplemental bundle. Which page?
Page 314. So, paragraph 2.2.
No, I haven't got that at 314. 314, I've got page 1080 of the screening of blood for hepatitis B. Must be looking at something else.
My 314, I'm in the hard copy, is headed Extract from the Memorandum of Understanding.
My lady, well, we'll have hard copies. Would you like a hard copy?
Keen on hard copies. When was it sent to me?
The electronic copy, so there was an updated supplementary bundle sent, I think, on Thursday of last week.
Thursday.
I think we actually had 3 separate supplementary bundles that got sent electronically.
Right, I've got the respondent's notice. Thursday the 20th. We better hand it up, I haven't got it. No, it hasn't. Okay, I've got it actually. Thank you. Got it on the screen. I've got the National Health Service Act.
Yes, my lord, if you turn to page 314. So the point about the cut-off date is not actually in the selection of the Memorandum of Understanding provided.
But we do know is, presumably following on from the way you put your case, we see, for example, at 1.3, a primary beneficiary is someone who is infected directly from NHS supplied blood or blood products, or someone infected directly from someone who was. But it doesn't say anything about screened or non-screened. So it doesn't say you're only a primary beneficiary if you received unscreened blood.
Yeah, that's right. And also paragraph 2.2, the purpose of the scheme is repeated that I've already identified in the directions.
2.2. I haven't got 2.2. Oh, yes, I have. To eligible individual. Right?
What's important, my lord, in terms of eligibility, and the authorities are consistent on this, you can't identify someone's status by the difference in treatment. So someone's status is not to be defined because they don't meet the eligibility criteria. So you can't define you can't draw a comparison between two people, one who does meet the criteria and one who doesn't. The ground for the difference in treatment has to be different to the difference in treatment.
Sorry, can you just say that again? Because I don't think I
Yes.
really...
It rather goes back to the quotation from Lord Lloyd Jones set out by Lord Justice Singh in MOC at paragraph 53. Where Lord Lloyd Jones says that the personal characteristic, which is the ground upon which someone is treated differently, is different from the difference in treatment itself. So the submission I make based on that is that you can't say that someone's status is that they don't meet the eligibility criteria of the cut-off date, for example, because that's the difference in treatment. The characteristic has to be different from the eligibility criteria. You can't define somebody just by the criteria they don't meet.
I know, but what I'm struggling with is the difference in... There is no difference in treatment in this case between a sufferer from HCV and a sufferer from HBV, because the scheme does not cover, I know it's by eligibility criteria and not stated in the purpose, but an HBV sufferer who receives screened blood is not covered, and an HCV sufferer who received screened blood is not covered. So there is no difference in treatment between the two groups. Now, what I don't understand is why that falls foul of what Lord Lloyd Jones says here. There must be a ground for the difference in treatment in terms of the characteristic, which is something more than a mere description of the difference in treatment. There isn't the difference in treatment to which you refer here.
My Lord, the comparator is a person infected with hepatitis C who does qualify for the scheme. Because that's what the discrimination is about. And the reason why someone infected with hepatitis B... So this claimant was infected in 1989 as a result of a blood transfusion. At that point, that blood transfusion could have contained hepatitis C or HIV, or probably not HIV by that point. It could have contained hepatitis C. It was fortune or misfortune or just chance.
But even if it had contained HIV, which wasn't screened until 1995...
1985, HIV. Blood was heated in 1985 to inactivate HIV.
And what about HBC? When was
Hepatitis C screening was introduced on the 1st of September 1991.
Right, so he could have got HBC from unscreened blood, and if that had been the case, he would not have been covered by the scheme.
Sorry.
Could have got I'm sorry, I've got the B's and C's mixed up. He could have got hepatitis C
Yes.
or hepatitis B
Yes.
in 1989, and he would have been covered if he'd got hepatitis C, which was unscreened,
Yes.
but he wasn't covered when he got hepatitis B, which was screened.
Yes.
Right. Okay.
So it's just a matter of chance that he was infected with hepatitis B, not hepatitis C, and so doesn't qualify for the scheme.
It's not a matter of chance. The scheme was set up because of the iniquity of a lot of people getting hepatitis from unscreened blood. And there wasn't a claim against the NHS, apparently, for that reason, because it was unscreened.
Well, my lord, in terms of whether there's a claim against the NHS, the respondent's position is contradictory on that. So the ministerial submission that was filed last night, let me take a step back. The respondent's case in the pleaded case is that those infected with hepatitis B or hepatitis C, when screening was introduced, can bring a claim, either in negligence or under the Consumer Protection Act, because blood was screened. So the respondent's case in the pleadings is that they could have brought a claim. So the ones who received screened blood could bring a claim, whereas those who received unscreened blood couldn't.
Well, that seems to be, at least have some logic to it. It may or may not be right, but certainly people who receive screened blood, you'd have thought could bring a claim, would you not?
Well, there's an argument that the National Blood Transfusion Service have taken a reasonable step by introducing screening as an additional step, and so that's not.
But it looks as if they may not have done the screening very well. I mean, your client's the living example of that.
That may be one reason. The other reason is just the screening was not particularly efficacious. Even at its best, hepatitis B screening is 80% effective. I'll take you to the evidence.
Is that a known figure?
It arises in the Penrose report.
Right.
So the government knew that the screening was not screening all the hepatitis B out of the blood. It was just an additional step. Other steps were taken in relation to safety of blood. So, for example, when a donor goes to a donation centre, they have to fill out a questionnaire. There's a risk assessment. That's a step.
So I mean, your point is that the purpose of this scheme was to help HIV and HCV sufferers, and nothing about whether the blood was screened or not. That's simply an eligibility criteria, and in those circumstances, it is discriminatory against people who are in a relevantly similar position, namely HBV sufferers.
My lord, yes, and it's telling that there's no reference, at least in the extract we've been given, and we can obtain a full copy of the memorandum of understanding provided. There's no reference to screening. So it's not the ground upon which the person is treated differently. It doesn't appear in the memorandum of understanding.
But it must appear somewhere.
Screening is the underlying reason for where the eligibility criteria have been drawn. It's not the ground for the difference in treatment.
Just picking up from what the Lord Master of the Rolls just said, where do we find screening then?
Well,
You were taking us to the eligibility criteria. You've said it's not in the. You told us, I think, that the eligibility criteria appear in this memorandum, but now you've also told us that screening doesn't appear in the memorandum. So where does the screening come from?
My lady, screening comes from the pleadings. So it's the reason why hepatitis B is not included in the scheme. So we've seen from the definition it's only HIV and hepatitis C. The reason why it's silent on hepatitis B is because government say screening was introduced.
No, but we have a cut-off date, wasn't it?
Yes.
The 9th of September 1991.
1st of September 1991.
Sorry, 1st
Yes.
September. So where do I find that date?
Well, my lady,
There must be a
I'm
bit of
going to
paper,
I'm going to have to provide a full copy of the MOU.
It's in there, is it?
Yes.
All right.
Well, I
You don't
anticipate it's in there because it's not in any of the legislation.
Right. Thank you.
Right, well, I think we got the point now. So,
My Lord,
could you just point me to the skeleton argument where that point is made? Your skeleton argument, just so that I...
my Lord, forgive me, which point in particular?
I mean, it seems to be only one point on relevantly similar, and that is that the purpose of the scheme is to cover people with HCV and HIV, and there's nothing in there about screening or cut-off, and that's not a personal characteristic, and therefore it's discriminatory. Where's that in your skeleton? I just want to have it in a good place that I can refer to.
Pages of a moment.
I think it's your paragraph 27 that comes closest to it, isn't it?
And paragraph 28, the end of 28 at the top of the next page. The boundaries of the scheme should not be equated with its purpose.
Okay, but there's no reference to... Is there a reference to the purpose of the scheme in...
Well, Lord, yes, it's set out at
16.
16.
It might be thought to be a cryptic reference to the point you've made orally.
The joy of oral submissions, isn't it?
Lydia.
I mean, it's absolutely critical to your submission. That is your case. And where is this stuff about characteristics in your submissions?
They are by cross-reference to the oral permission hearing skeleton, because, of course, ambit was not an issue when this appeal was first lodged. So, in the oral permission...
relevantly similar was an issue. The word characteristic is not even in your skeleton, right?
Well, Lord, in the skeleton argument, in relation to ambit,
and I'm not saying the point's not open to you. I'm just really.
it's paragraph 27, my Lord. That's setting out what Lord Reid says in SC. And 28, 27 and 28. And 29.
Yeah, I mean, I understand that you say hepatitis is hepatitis. What I didn't understand was why you said it wasn't open to the department to treat screened blood and unscreened blood separately. That's what I didn't understand from your skeleton. Now I do. I mean, it's not a complaint, Mr. Appellant. You carry on. It's as my lord said, it's cryptic. It's sort of there, but it's cryptic. Anyway.
Well, there's perhaps another cryptic reference, paragraph 35C.
I mean, the other point is, was this point put to the judge?
Well, Lord, yes. It was one of the relatively similar situations. Was one of the main points between the respondent and the appellant.
So where does she set out that argument?
Paragraph 16 of the judgment. Yeah. Final 5 lines, beginning with Mr. Howells.
I don't see that as talking about the purpose of the scheme or the fact that screening is not a justification, is not, doesn't make them relevantly dissimilar. Anyway, there we are. I think we've got the point.
My Lord, it may also assist if I give the court the reference to RJM, which is paragraph 5, Lord Walker, page 88, where he discusses personal characteristics.
Could you give me the page again in the bundle?
Page 88, Lord.
88. So other acquired characteristics are more concerned with what people do or with what happens to them than who they are. They may still come within Article 14. And that rather seems to be contrary to what you're saying. So a person suffering from HBV caused by receiving treated blood, I mean, it's certainly a characteristic to say you're suffering from HBV, arguably a further concentric circle outside that to say you're suffering HBV after being treated with treated blood.
My Lord, in my submission, it's at least arguable that's a step too far, and that conflates justification, the reasons for drawing the scheme with someone's personal characteristic, the ground upon which they're treated differently. I can dig out the references when I sit down, my Lord, but on a number of occasions, I think in particular, it may be in SC, the Supreme Court has said that courts, not that I'm suggesting that's the case here, but make heavy weather of a relatively similar situation, and actually what should be focused on is there a difference in treatment, and is it justified? Those are the key points, and courts can get distracted by trying to identify the relevant characteristics.
Well, it's the same problem as they have in discrimination generally, and Shamoon said, okay, you can spend a great deal of time and effort analysing whether you're in a relatively similar situation or what is a true comparator. Actually, the better question is, has there been unjustifiable discrimination?
Quite.
I mean, it's obviously different in direct discrimination because that arm of domestic law can never be justified. The European Convention on Human Rights, which you're relying on, is obviously different.
Yes, and direct discrimination, particularly on suspect grounds, we'll come on to this in a moment, can only be justified for the very weighty reasons.
Yeah, but are you contending that the status, the difference between hepatitis B and C is a suspect ground?
Well, Lord, yes, it relates to disability, and in fact, one of the authorities of the European Court of Human Rights specifically refers to HIV as being a suspect ground. And we'll come to that when I take the court to SC on justification. And so perhaps that's another way of dealing with it, my Lord, is that if you've got my submissions on relatively similar situation, the ground upon difference of treatment can't be conflated with the reasons for it and the justification. But ultimately, the important question what is the difference in treatment, and can it be justified? And as I say, I'll try and find the references. They're doing a search in the authorities bundle to courts making heavy weather of this point.
Well, that brings us straight into justification.
Lord, yes. It was agreed between the parties at the oral permission hearing that the correct test was the manifestly without reasonable foundation test, because the Supreme Court in DA was pretty clear about that. That was the correct test. And it's clear that Mrs. Justice Stacey was applying that test in the judgment. So, for example, if I could ask your lordships and your ladyship to go to the judgment of paragraph 20. Page 35 of the core bundle, where Mrs. Justice Stacey said the defendant has demonstrated reasonable foundation for the boundaries in terms of the scheme. So I pause there. Reasonable foundation is quite clearly a reference to the manifesto without reasonable foundation test. The judge makes a mistake there in referring to for the boundaries in terms of the scheme, because of course it's the difference in treatment which has to be justified, not the boundaries of the scheme. Indirect discrimination, it's the scheme that has to be justified, where you can show a prejudicial impact on a particular group, but in direct discrimination, it's the difference in treatment that must be justified, not the scheme itself.
But you're not in direct or indirect, you're in Article 8 or A1P1 and Article 14. Direct and indirect is domestic law.
My Lord, there is a distinction between direct and indirect in Article 14.2. I don't want to go down that road.
No, and the European Court of Human Rights, I mean, that's another unproductive sort of alleyway to get into, which avoids the real issue.
Yes, and SC very much, Lord Reed and SC very much concerns himself for a period in the judgment with indirect discrimination.
Yeah. You
have to show by statistics prejudicial effect, disproportionate effect on a particular group of people by a measure that appears to be neutral. So that's indirect, but I'm not using indirect discrimination in this case. And then also, at paragraph 22 of Mrs. Justice Stacey's judgment, special circumstances led to the introduction of the various schemes and the English Effective Blood Support Scheme for hepatitis C and HIV do not therefore apply to hepatitis B, and, together with temporal limitation, provide ample reasonable foundation and objective justification for the difference in treatments. Quite clearly, Mrs. Justice Stacey applied, as she was invited to do so, the manifestly without reasonable foundation test. However, following obviously the Supreme Court decision in SC, we now know that the test is a lot more nuanced and flexible than that. But in particular, where discrimination is on a suspect ground, and they are identifiable through the case law of the European Court of Human Rights, there must be, notwithstanding that it's in the field of social security, and normally you would show margin appreciation, and so the manifestly without reasonable foundation test would apply. Where the difference in treatment is on a suspect ground, very weighty reasons for that must be shown. If I could take the court to the judgment of Lord Reed, tab 15, page 330. Paragraph 112 and 113. If I can invite the court to read it.
Yeah.
So in particular, paragraph 113 the court will see that being HIV positive is a suspect ground. And just under B, the sentence beginning, it is also a further illustration of the link between the need for very weighty reasons and the stigmatising of particular groups in society. The full point is that disabled people and persons infected with HIV and hepatitis E and hepatitis B are stigmatised in society. The current appellant was, and so that's why suspect very weighty reasons are needed before the state also embarks upon discriminatory provisions for someone who's been discriminated against by society.
Well, are you just reading this a wee bit too quickly? What had happened was in DA, they said, Lord Wilson had said, manifestly without reasonable foundation applies to all. In SC, Lord Reid said, no, actually it's more nuanced than that, and you've got to look at what is being justified in particular. And at paragraph 112, he says a relatively strict approach has been adopted in cases concerned with disabilities, because you're right, disability itself is a suspect ground, but you're also dealing with economic decisions made by government where courts would allow a wider latitude. So I think it would be wrong to say we should apply manifestly without reasonable foundation because you've got disability, but it would also be wrong to say that you just ignored the fact that this was in the area of state benefits where there was no obligation to provide. So it has to be a nuanced, careful, considered approach.
My Lord, absolutely. Can I take your Lordship to paragraph 158, where Lord Reid makes the point that your Lordship has just made?
I mean, as long as that's common ground, that's fine. It's just I had misunderstood your submission to be very weighty reasons, full stop, end of story.
No, if there are particular reasons that justify departure from that approach in any given case, then the court can move. It's a flexible principle depending on the factors that are engaged in the case. But at paragraph 158, what Lord Reid says at H is this, and it's at page 344 of the authorities bundle at the bottom. In light of that jurisprudence as it currently stands, it remains the position that a low intensity of review is generally appropriate, other things being equal, in cases concerned with judgments of social and economic policy in the field of welfare benefits and pensions, so that the judgment of the executive or legislature will generally be respected, unless it is manifestly without reasonable foundation. Nevertheless, the intensity of the court's scrutiny can be influenced by a wide range of factors, depending on the circumstances of the particular case, as indeed it would be if the court were applying the domestic test of reasonableness from the convention test of proportionality. In particular, very weighty reasons will usually have to be shown, and the intensity of review will usually be correspondingly high if a difference in treatment on a suspect ground is to be justified. Those grounds, as currently recognised, are discussed in paragraphs 101 to 113 above. I've taken you to 112, 113, suspect ground, and that's general principle he identifies is that usually very weighty reasons will be required. But your Lordship is absolutely right. It's a sliding scale depending on the factors that are
because there's no legislative entitlement to this scheme, but it was, established as ex gratia. It's then put on this sort of footing with the regulations, and it is in that area of economic. On the other hand, it engages, as all the evidence shows, very intimate matters of personal life and your ability to participate in society.
Oh, yes. The respondent makes the point in the skeleton argument that the judge in paragraph 19 of her judgment refers to rigorous scrutiny and careful attention. Perhaps my lady would assist if I took you to the judgment. So it's judgment paragraph 19, page 35 of the core bundle. Three lines down. Let us also assume at this stage of the proceedings that we should adopt the highest possible threshold of the objective justification test advanced by Mr. Howells, that there must be a significant and proper explanation for the policy decisions made which withstand rigorous scrutiny and careful attention. Even then, the defendant has already demonstrated compelling grounds to the scope of the coverage of the English effective blood support scheme, and ground one is not reasonably arguable. I've taken your ladyship to paragraphs 20 and 24, where the judge quite clearly refers to the manifestly reasonable foundation test. What is being said at paragraph 19 is my reference to what Lord Justice Singh says in the Crown on the application of TD and the Secretary of State for Work and Pensions, which is at tab 12. Page 223. Paragraph 64. So it is important also to know what Lord Wilson said at paragraph 66 of DA, where he emphasised that the court will proactively examine whether the foundation is reasonable. This is consistent with what was said in the two cases cited by Lord Wilson, that there should be careful scrutiny of the reasons advanced by way of justification. So I took the judge to that passage and said, even though we're applying the manifestly without reasonable foundation test, when you're looking at the reasons given by the Secretary of State, you have to apply careful scrutiny. So at paragraph 19, that's what the judge is referring to. It's arguable in this case that there are not very weighty reasons, and so the discrimination can't be justified for a number of reasons. Firstly, as the respondent has not considered the position of persons infected with hepatitis B, little weight need be given to the ex post facto justification. Although
Sorry, just say that again. Little weight needs to be given to the ex post justification because
the respondent has not himself considered the position and the discriminatory effect on those infected with hepatitis B. So the court, the principle is, the court attaches weight to the view of the Secretary of State. If the Secretary of State hasn't considered it, little weight needs to be attached to ex post facto justification. And there's an authority for that. It's still TD, which hopefully the court still has it in front of it, and it's paragraph 53 to 54, page 221, so 2 pages up. This is relevant also to my rationality grounds, and may I take the court through it. Paragraph 53. It is well established that under the Human Rights Act, the question of justification for an interference with the Convention right is a substantive question, not merely a process question. In this regard, it differs from conventional grounds of domestic public law. For example, it will not suffice the decision maker has taken a relevant consideration into account. What matters is whether the ultimate decision taken is or is not objectively justified. Conversely, unlike in domestic public law cases, it will not necessarily be fatal if the decision maker has failed to take into account an issue under the Convention. It is the compatibility of the outcome of the process with Convention rights which has to be assessed by the court, not the process by which the outcome was reached. That said, it is also well established that the fact that an issue has been considered by a decision maker is relevant to the question which the court itself has to determine. It may affect the weight which the court should give to the views of the decision maker when coming to its own assessment of the issue of justification. This is the point to which the judge made reference to paragraph 65 of her judgment, where she quoted Lord Kerr in Brewster, and then sets out what Lord Kerr said, where a conscious, deliberate decision by a government department is taken on the distribution of finite resources, the need for restraint on the part of a reviewing court is both obvious and principled. Decisions on social and economic policy are par excellence the stuff of government. But where the question of the impact of a particular measure on social and economic matters has not been addressed by the government department responsible for a particular policy choice, the imperative for reticence on the part of a court tasked with the duty of reviewing the decision is diminished.
Can I just ask, what is, and I appreciate we're at the permission stage at the moment, what is the evidence about who considered what? They must have considered screening to have avoided putting in hepatitis B. So why do you say the respondent didn't consider the position of the claimants?
My Lord, it's always been, as I set out in the note and all the references are supplied there, it's always been the claimant's case that in 2017 the position of those infected with hepatitis B was not considered, and the respondent has never challenged that. In 2004, when the first scheme for those infected with hepatitis C was set up, the Skipton Fund, it was set up, as the respondent says in his skeleton argument, partly in response to the group litigation by those infected with hepatitis C. So it was a scheme that was set up in response to group litigation by hepatitis C. In my pleadings, the point is made that it's unlikely that the position of those infected with hepatitis B was considered then either. And the respondent has never taken issue with that. So there is no material before the court which evidences that the respondent has ever positively considered the discriminatory effect on those infected with hepatitis B. And when the respondent puts forward the reasons that he does, including screening, it is ex post facto justification. And in fact, one of the references to the respondent's skeleton argument is where the respondent makes the point that the decision to establish the scheme was to provide for those infected with hepatitis C, not to exclude those with hepatitis B. That's rather making the point that they thought that the scheme was to provide for those infected with hepatitis C, but no consideration was given to the discriminatory effects on those with hepatitis B. It was never positively considered.
But consideration was given to excluding those who were given screened blood.
My Lord, yes, but those reasons have never been provided.
Well, I mean,
Save to the extent
I mean, it's
that
obvious that it was considered, or that wouldn't have been an eligibility criterion.
Yes, but the reasons, my Lord, as to why the difference was struck have not been provided. So I accept
But I mean,
point.
you still have to really deal with the question of why, if an HCV sufferer who was given screened blood is not covered, your client should be covered.
Well, my Lord, the difficulty with that, and I accept that there is a comparison between the two, but those infected with hepatitis C, after screening was introduced, have been granted permission to challenge the scheme on rationality grounds and
Well, then
discrimination.
we're coming back to Chalice.
Yes,
We can't assume that Chalice will be successful because they've been given permission.
my Lord, no, but the application in this case was that they are similar and they should be linked. But unfortunately, a paper decision was made to refuse permission in this case before deciding the application to link them. And so I accept the point that those infected with hepatitis C after 1991 are treated the same, but I don't accept that that's justifiable because permission's been granted to challenge it.
Well, that doesn't mean that it becomes unjustifiable. That just means that a judge considered that point arguable in relation to the screening. And as you've, I think, fairly acknowledged, because of the blurring issue that was there, which
Yes.
particularly engages the issue of rationality, because you might have ended up with an unscreened product and you're excluded from the scheme. Here, the screening was from 1972, and therefore, given the relevant date of the blood transfusions and transplants, there couldn't have been an issue about whether it was screened. There's probably an issue about whether it was effective.
My Lord, as I said at the outset, the challenge in Chalice is not limited to that blur. It's a broader challenge to the rationality of treating.
Do we have the grounds in Chalice? We've got the decision, which is 113. If you're going to put a lot of emphasis on it, then I think we do need the grounds.
My Lord, yes, it's in the supplementary bundle at page 294.
Thank you very much. Yeah. And permission was granted on grounds 2 and 3, wasn't it?
On rationality and discrimination, yes. So it's paragraphs 27 and 28 of the grounds that contain the broad rationality challenge. So the situation really is this, that as Your Lordship, the Master of the Rolls identified, that those infected with hepatitis B and those infected with hepatitis C after the 1st of September 1991 are coming at this from the same angle. But one has been granted permission, and so far the other one has been refused. And so there's a difference in treatment for cases that are materially similar. That is why, when this claim was issued, an application was made to link it, because one affects the other.
Was there any decision about the decision to link?
My Lord, no. So the paper decision by Mr. Justice Martin Spencer just refused permission because it was unarguable and out of time, and didn't deal with the application to link as a preliminary issue. The claimant submits that it would have been.
Well, I mean, it would be open to us if we decided to give permission to link them.
My Lord, you are absolutely invited to do so. There's a permission hearing in Chalice on the 4th of February on the grounds that were refused. So there's a renewal hearing, for example, on the mistake of fact ground on Chalice. Chalice also argues the Secretary of State assumed that no infections of hepatitis C occurred after the 1st of September 1991, and that was a mistake of fact. So there's a renewal hearing on that. So if this court grants permission before the 4th of February, then it is indeed possible to link them and for this case to be
It may or may not give a decision, but we will have to think about that.
Oh yes, but I implore the court to, if you grant permission, to link them.
I mean, presumably the 4th of February could be delayed if it needs to be anyway.
Oh yes, if your lordship
Or
made
linkage could take place afterwards.
yes, I mean, if your lordship made an order that indicated a view that if it's not possible for them to be linked by the 4th of February,
It would probably happen.
it would probably happen. If I move back to my point on justification.
Well, you've got the first one done, so we're
My lord,
now
yes.
number 2, I expect.
Number 2, my lord. The justification put forward in the summary grounds for resistance at paragraph 23, at page 85 of the core bundle. Page 85, paragraph 23, the respondent submits submitted in the pleading that even if the claimant does have another status, it is denied that he is in a relatively similar situation to those found to have been or accepted as having been infected with hepatitis C through contaminated blood prior to September 1991. Negligence claim brought by a person with hepatitis C prior to September 1991 would have faced very significant difficulties in light of the state of knowledge and science at the relevant time. Routine testing for hepatitis B was introduced in 1972. There would, as such, have been no equivalent defence in relation to a claim brought by someone infected with hepatitis B after 1972. That's wrong. In the authority of A in the National Blood Authority, which is in the authorities bundle, I don't intend to take the court to it, but it's in the authorities bundle at tab 7. Successful claims were brought by persons infected with hepatitis C after 1989, so before the 1st of September 1991 cut-off. Also, Mr. Justice Burton found in that case at page 79 and at paragraph 10 on that page. So the paragraph numbering is a bit odd in the judgment because it's in sections. So page 79, paragraph 10. Mr. Justice Burton found that surrogate testing, I pause there, I should probably explain what that is. So before the virus for hepatitis C was isolated in 1989, there was a school of thought that proposed testing for liver function, ALT testing, so increased liver enzymes, showing that there's inflammation of the liver, something's going on, this hepatitis, could be caused by a virus, could be caused by alcohol intake, could be caused by obesity. but it's an indication of liver function. You could combine that test with screening for hepatitis B antibody. And the thinking was that if you screen for hepatitis B antibody, it shows that that person has previously been infected with hepatitis B. If that person has previously been infected with hepatitis B, that increases the likelihood that they've been infected with hepatitis C. So by combining those two tests, continued increased liver dysfunction and the fact that it's previously been infected with hepatitis B, that was a surrogate test for non-A, non-B hepatitis, as it was then called, because the virus hadn't been isolated. So that's surrogate testing. Mr. Justice Burton found that should have been introduced before 1989, because it would have reduced the number of infections of non-A, non-B hepatitis. And in my submission, therefore, those infected with hepatitis C during that period could have brought negligence claims. And so, in my submission, the reasoning given by the respondent in that paragraph, the summary grounds of refusal, are wrong. That's the second point.
Well, part of the reason is wrong.
Yeah. The third point, as a bolt-on to that second point, actually, I would make the point that liability, questions of who may be able to bring claims or not, is not relevant to an ex gratia scheme and the purpose of the scheme I've identified. Questions of liability is a mismatch between that justification and the purpose of the scheme. My third point is that it
Sorry,
follows...
can I just ask you, why do you submit that? Because one might have thought that it was very relevant. If you're going to, people have no claim, you can well understand why, if they've suffered catastrophic losses, the government might feel moved to do something about it. But if they've got a possible claim, well, leave it to what the law is. So it seems a very rational basis for distinguishing between two sets of persons.
Well, bearing that in mind,
Yeah.
can I move on to my third point as a direct answer to that?
Yeah, okay, fine, yeah.
My third point is that the respondent has now pivoted and now seeks to argue, paragraph 34 of the skeleton argument, and perhaps I should take go to paragraph 34 before I continue. I have the replacement skeleton as a loose document.
I think it's divided 19, isn't it?
I've got it a loose screen.
So paragraph 34, the respondent submits that, that being said, the judge was correct to find the appellant was not in a relatively similar situation to those found to have been accepted as having been infected with hepatitis C through infected blood prior to September 1991. In the case of the former, I think that that's a reference to those infected with hepatitis C. And then subparagraph B, that a no-fault compensation scheme would have avoided the need to defend potentially a large number of civil claims by those infected by blood unscreened for hepatitis C before September 1991. Defending such a claim would have been extremely expensive, even if the defences had been successful, because before routine screening was introduced, it would have been difficult to identify who the blood donations were. So the respondent is now making the opposite point. The respondent is now saying we set up this scheme because otherwise we'd have to defend all these claims. And claims brought before screening was introduced would have been very difficult. That comes from the ministerial submission that was filed this morning. I ask your lordships to turn up the ministerial submission.
Who filed it?
The respondent, in response to the note I filed yesterday afternoon.
So is this going in the authorities bundle or the supplementary bundle?
Supplementary bundle, my lady.
So this is the ministerial statement.
Ministerial submission, so the advice given to the minister, who I understand decided last week or the week before not to change the cut-off date in 1991 for the moment.
We're just going to wait for the results results of the inquiry.
Yes.
And when's the result of the inquiry expected? When is the inquiry expected?
My Lord,
to report?
I hesitate.
You have no
because
idea.
it's quite like asking how long is a piece of string at the moment.
I see. And I thought there was some expectation.
Are you in the inquiry then?
My Lord, yes.
Yeah. And so what stage has it got to? Has evidence been completed?
No. So the latest indication, and indications change every few months, is that evidence will be heard for the rest of this year.
Because somewhere in the papers it said the report was...
That was mine.
Expected.
Yes.
Yours.
My lady, the report was expected mid-2022.
Yeah,
that is simply not going to happen.
All right.
So what further evidence is now being heard?
But at the moment, the inquiry is hearing evidence from regional transfusion directors and directors of the National Blood Authority on blood transfusion practice.
And so evidence completed by the end of this year, closing submissions,
My Lord, I don't know.
and so no report.
So there was recently an outreach meeting which involves the Secretariat meeting with infected and affected persons. And the indication given then was the report's not going to be before mid-2023.
Yeah.
So, I mean, that makes, in a sense, makes this case potentially more important. Because if the Minister was going to reconsider and the report was imminent, it would be something, but that's not the case. This is going to be a long job.
Lord, yes. And with my note yesterday, I filed the transcript of the evidence of Mr. Hancock and Mr. Vanille.
Yes, I didn't have time to look at it, so you'll have to refer us to it if you want us to.
Well, I can summarise the effect, is that
Yes.
Mr. Vanille, the senior civil servant, was asked by counsel to the inquiry whether he'd seen any documents that showed in 2017 whether the government had ever given positive consideration to those infected with hepatitis B. The answer was no. And then the question was asked, are you now going to consider it in light of the evidence this inquiry has heard about continuing infections with hepatitis B after 1972? And the answer was no. It's not their intention to review the position of those infected with hepatitis B. At least that was the stated position in May 2021.
I mean, could you give me an idea? This is just something I don't understand. I probably could have understood it. You're obviously a great expert, Mr. Howes, in all this, having spent so long with the inquiry, but I'm not, and so I need help. The prevalence of HBV, HIV, and HCV, is there some sort of easy understanding of how common they are? I mean, we've got the 20,000 versus 25 figure. That's very stark, but...
My Lord, the short answer is no. It's controversial.
Right.
The inquiry has a team of statisticians who will be giving evidence to the inquiry in due course, whose job it is to try and estimate how many people have been infected with hepatitis C, with all viruses. The government carried out...
Sorry, just tell me something else. If a person has HCV, has hepatitis C, do they automatically know it? How serious is it?
No, it can lay dormant for 30 or so years. We only know 30 years because that's how long it's been. It could be more. So
Right.
people are still now developing symptoms for the first time,
And then they do get symptoms later, always, or just sometimes?
well, we don't know the answer to that,
I
my
don't
Lord.
know the answer to that either.
Because
What
you've only
about?
got 30 years.
Because
under the belt.
we can only go on what's happening at the moment, and people are finding out suddenly now that the blood transfusion they had 30 years ago has given them hepatitis C.
Right, and okay, and hepatitis B, is that less prevalent? Is that generally accepted to be less prevalent but more serious, or what?
I wouldn't take issue with the statement that it's less prevalent.
Right.
I would take issue with the suggestion it's not as serious.
No, I said more serious.
Well,
Hepatitis B.
It's
is-
not more serious, no, my lord, it's the same. So
Same.
the effects on the liver, it causes cirrhosis of the liver and liver cancer. It causes what's been termed brain fog, so it affects cognitive functioning. It can cause all Hodgkinson's lymphoma. It can cause all sorts of complications.
And it can lie dormant like a
Yes,
hepatitis C for a period.
Yes, but the difference between hepatitis B and hepatitis C is that you can have natural clearers of hepatitis B.
You can have what?
Natural clearers. So it just clears in the body without any
Hepatitis
treatment.
B can
Yes.
disappear,
Yes.
but doesn't commonly.
So that is the distinction between a test for the surface antigen, which is a test for current infection, and the test for the hepatitis B antibody, which shows that you have previously had an infection.
Right.
But sometimes with the surface antigen test, there is such a low titer of the virus in the blood that it returns a negative test, whereas in fact that person does have an infection. So the antibody test is a fail-safe that can identify infection even though the antigen test is negative.
Can I just ask you about the treatment of these conditions? I mean, obviously we've read what your client has said about his terrible circumstances, but are they generally treatable, and is there any difference in the treatment between C and B?
I believe the treatment is the same. Treatments have changed over the years. The first treatment was something called interferon.
Yeah.
And it
Which
was,
your lay client had an appalling reaction to.
Absolutely.
They kept trying and trying.
lots of people did. Interferon was an
I was going to
awful,
ask you, was that a common response?
yes,
Yeah.
it was an awful treatment, and it caused flu-like symptoms for years on end. And it was not particularly successful. The inquiry heard from people infected who had 3 courses of interferon treatment and through all that suffering and still didn't clear the virus.
Position now?
So the position then became that recombinant treatments were introduced, which were much more successful. Recombinant.
Yes.
Much more successful and not as severe in terms of the side effects.
And that's for both C and B.
Really, yes.
So there really isn't any difference in symptoms or treatment, or severity and treatment.
Although that's why I submitted that hepatitis is hepatitis.
What is the difference?
The virus?
It's just a different virus,
It's a different virus.
but related virus.
Related. So there's a hepatitis G. So there are a number of hepatitis viruses. They have different effects on the body. Hepatitis A.
Are they identified as time goes by? I mean, are
Yes.
they, you know, we're all very familiar with viruses just at the moment in COVID terms, but presumably hepatitis, does hepatitis produce new variants?
I don't know.
I mean, hepatitis G is not one I've heard of before.
Wasn't one I'd heard of prior to the inquiry.
Yeah.
I think it's a process of elimination. So you know that there's, as happened with hepatitis C, so they knew in 1978 that there was a hepatitis A and then there was a hepatitis B.
So is this similar, sorry to suppose, but for example, one knows from reading about, for example, various different cancers, take breast cancer, they get more and more knowledge so they can strip it out. So instead of a global breast cancer, there's this type, that type, the other type,
Yes.
all identified in more and more specificity as research develops. And are you saying it's broadly similar with hepatitis?
Well, it is.
As scientific progress has come about, they've worked out this B, C, now G.
Yes, well, that's exactly
But
it.
your submission is, but it's all hepatitis.
Yes.
Like it's all breast cancer.
Well, yes.
Or it's all COVID, but it's this, that, or the other.
But I was asking you about prevalence, and I was, as I say, struck by the 20,000 versus 25 figure. You would say, would you, and it doesn't have to be a documented submission, that that's misleading because we just don't know.
We just don't know. It's certainly more than 25.
And anyway, that because the difference between B and C is so insignificant in many respects, there may be a difference in numbers, but it doesn't matter.
It doesn't matter.
Just picking that up, if I may. I think you told us that one of the difference in numbers is also, of course, there was this huge period of time when C wasn't screened, whereas B has been screened since 1972. So the 25 relates to continuing post-72 in many cases, where there has been what's effectively ineffective screening for some reason.
Well, yes. I think the point is that if screening for hepatitis C had been introduced at the same time as screening for hepatitis B, the figures might have been comparable.
So if we turn it on its head, if hepatitis B screening had not come in, until
Yes.
1989,
Yeah.
then you would have a more accurate comparison as to the natural prevalence of these.
Lady, yes.
Is there a document that gives us a simple introduction to hepatitis? The differences between the types and its comparison with HIV we haven't discussed yet. But I mean, I don't want to spend a lot of time. If there's a few 5 or 6 pages I can just read.
There's an expert report provided by hepatitis experts to the effective blood inquiry, so I can certainly download that and provide it to the court.
And it's just a beginner's guide. I mean, I'm sorry to sound so ignorant, but it's not my field of expertise.
No, well, no, not at
Medical
all.
negligence and hepatitis is something I don't
I can
know a
download
great
the
deal
expert
about.
report on hepatitis and provide it to
It
the
would
court.
help me, thank you.
They also give evidence, there's a transcript, whether you need that much, I doubt it.
Well, I don't want to read months of evidence, that's for sure.
No, I think it was 2 or 3 days worth of... but I'll apply my mind to it, my lord, and I'll provide the court with something.
Okay, thank you very much. Now, we've got to reason 3,
My
about
lord,
the rational basis for the distinction.
yes, and
You complain that they've changed their mind from saying, they used to say that people who had screened blood could sue, and now they're saying that they did it because those with unscreened blood would be difficult to defend.
my lord, yes, and I wanted to take your lordship to page 6 of the ministerial submission.
Yes, got that.
And it's the bullet point at the bottom of the page that carries over. So removing the cut-off date would effectively open up the scheme to those who would fail in a legal claim, i.e. no fault compensation. This could set a difficult precedent for people in a similar position to the claimant, such as those affected with hepatitis B, who are defending a challenge from someone affected with hepatitis B on the basis that all blood was screened. So that's expressly saying, if we open up the scheme to those with hepatitis B and those infected after the cut-off date, it's a no-fault compensation scheme because their claims would fail. It's the complete opposite point to the pleading that the respondent made in this case, which shows the dangers of the court placing weight on ex post facto justification. And if I may take the court to the judgment of Mrs. Justice Stacey,
Yes.
paragraph 20, my lord. If I can invite the court to read paragraph 20.
You said it's not right to say that the purpose of the policy was to assist those who had contracted those conditions when blood was not being screened.
But it's also the point that the learned judge placed weight on the pleading that it was about legal claims. And now the respondent has pivoted. So, my lord, that's point 3. Point number 4, as to the differences in the size of the cohorts of those infected, in my submission, this is illogical, although I have your lordship, Master of the Rolls' point that you made earlier. But in my submission, it's illogical and not a weighty reason. It's more difficult to justify exclusion of a small number of those infected. And the use of the phrase special circumstances, in my submission, is circumlocution. Point number 5.
Yes.
The respondent's reliance on the Supreme Court decision in the Crown on the application of RJN and the Secretary of State for Work and Pensions, tab 8, page 101, for the proposition that the respondent is entitled to adopt bright-line rules is misplaced in my submission. The point that Lord Neuberger was making in paragraph 57 is that the line can be drawn where it's justifiable. So if I can take the court, paragraph 57 of Lord Neuberger's judgment, tab 8. Page 101.
Yeah.
Second sentence. Equally, the fact that the line may have to be drawn imperfectly does not mean that the policy cannot be justified. Of course, there will come a point where the justification for a policy is so weak, or the line has been drawn in such an arbitrary position that, even with a broad margin of appreciation accorded to the state, the court will conclude that the policy is unjustifiable. So, Lord Neuberger's judgment is not authority for the proposition that the Secretary of State can draw bright line rules unless they can justify them.
No. Okay.
And the final point is point 6.
Yes.
The submission made by the respondent that hepatitis B screening, the idea that the respondent accepts the hepatitis B screening was not effective in the 1970s, between 25 and 50% effective. It grew in efficacy to about 80% by the 80s. The idea that the respondent accepts that for blood transfusions, and that it was particularly ineffective in relation to pooled blood products. So pause there, I should probably explain that. So blood is a pint of blood taken from one person and transfused into another person. Blood products are where the blood is centrifuged and the different components of the blood are taken out. And for example, clotting factors are given to haemophiliacs who don't have clotting factors in their blood. In order to centrifuge the blood, you have to have about 20,000 pints. So it only takes 1 pint of blood to infect the badge.
Yes.
That is why blood products are so more infective.
Well, because they concentrate.
Yes. But it's important to bear in mind that this scheme applies to those infected by blood and blood products. It applies to both.
Yeah.
So the persons continued to be infected with hepatitis B after 1972. So for the purposes of this claim, or this appeal, the respondent accepts that for the moment. But because there was a form of screening, they were in an entirely different situation from those infected with hepatitis C. My submission that is seriously flawed for reasons that we've explored at length.
Yep.
I alluded to it. Steps were taken to reduce the risk of hepatitis C infection. Donation questionnaires, policies to limit the use of blood products, etc. To circumstances where, for example, children were not given pooled products if it could be avoided. The hepatitis B screening was just an additional step in that process of risk management. It was not a golden bullet. For example, antibody testing, which was not recommended as an additional safeguarding test, would have screened out more people and prevented more hepatitis B infections, but it wasn't introduced.
Well, your point is that it's not really a proper distinction. It's a distinction without much difference because measures were taken to avoid infection, and the fact that there was screening is only partially effective anyway. It's just one way of avoiding it if you can, but
yes.
It's not a bright line rule.
Oh, yes.
Yeah, okay, get that. It's also 1 o'clock.
Well, my Lord, I think I've finished on Article 14. I have about 8 lines on rationality. I can take it very quickly. I'll come back after lunch.
If it's very quick, let's do it now.
In terms of rationality, as pointed out by Lord Justice Singh in TD, and I've already taken the court to it, whilst the respondent can rely on ex post facto justification for the purposes of Article 14, because the question is for the court whether it's objectively justified at the time that the court is looking at it, he cannot do so in response to a rationality challenge.
Sorry, the Secretary of State can't rely on what?
Ex post facto justification.
Oh, okay.
Because if the point was not considered and the reasons identified, there's a tame side challenge. Fail to take into account all material considerations and make relevant inquiries.
Well, yes and no. I mean, you've got to be careful about making sure all your submissions are consistent. You rightly pointed out this is a continuing act, or say arguably pointed out, and now you're going back to the original actions back in 2004.
No, forgive me if I've given the wrong impression. The point I make is that I very much rely on this as a continuing act. It's a continuing failure of the respondent to consider the position properly.
Right.
That's the point I make on rationality. And moreover, there is a mismatch between the reasons put forward by the respondent and the purpose of the scheme, and I rely on the judgment of Mr. Justice Swift in Howard, tab 14, paragraph 35. That could be a species of rationality where the justification for a scheme don't match the purpose of the scheme. And finally, you've seen the ministerial submission, and that was decided upon by the Minister last week or the week before. Those with hepatitis B were not considered. And in my submission, that's irrational to consider the position of those infected after 1991, who the government have always maintained are in the same position as those affected with hepatitis B. But when you're considering those affected with hepatitis C after 1991, you don't consider the position of those affected with hepatitis B. But those are my submissions, unless I insist any further.
Thank you very much. I hope we're not in danger as to time, Mr. Tankle. You've perhaps been limited a little bit more than you may have hoped, but we must finish at 4:15 promptly this afternoon. Is that all right? Yes, well, you'll begin at 2 o'clock promptly. Thank you.
Yes.
Brian from the Press Association. No monumental elect. How long are you?
Well, I've just finished my submission.